All right.
The Honorable Jared Smith, Judge presiding. All persons having business before the court draw near to the attention and will be heard. May God give the United States of America, the state of Florida, and this honorable court. Please remain standing for the legislation.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. All may be seated. Good morning, everyone. We're here just for one case this morning, 23-3806, and we can have counsel for, I'm going to say Filster, but somebody's going to correct me on that, I'm sure. Filster and the activity group come forward, and you can let me know how much time you'd like to save for rebuttal. Okay.
You'd like 5 minutes to follow.
Okay, perfect. Great. All right, you may begin. I mean, I'm not going to start trying to tell you up there, but come on. And I apologize. Let me introduce my colleagues too. We have Judge Joshua Miles to my right, and Judge Rick Orfinger is joining us to my left. Okay, so thank you.
Morning, Your Honor.
Good.
Yes, and may it please the court. I'm Zachary Zerm. I have the pleasure of representing Filster in the activity group. So the facts underlying this case are fairly simple. The defendants in this case took roughly 205 firearm holsters valued at about $30,000 without paying for them. We sued to get them back, and the lower court dismissed the case with prejudice. Now, again, those are decidedly simple facts. We initially brought this case a conversion claim. You know, it's the gist of the conversion hinges upon it's our stuff. You have them, please give them back or pay for them. That unfortunately didn't happen here. Instead, in response to a form conversion complaint promulgated by a Supreme Court, the defendants, the appellees in this case, filed a motion to dismiss, calling the form complaint a hodgepodge.
Let me ask you a question. You know, a form complaint presupposes that it's just a form complaint. Okay. You didn't have just the form complaint, at least in your Second Amendment complaint that we're on here today. Kind of the conversion count contains the form complaint, but then you also have all these general allegations.
Yes, sir.
And in some ways, some of those general allegations seem to counteract the conversion claim to me. So, to say that analogize this to cases where somebody just used the form complaint and a court said that was enough, to me, we're just not that case, right? You have other allegations and you got to deal with those. And it seems to me that some of them defeat the conversion claim, namely that your general allegations allege they purposely, gave the holsters, right? A sale occurred. Now, a sale might have occurred under false pretenses in the sense that you allege, well, hey, this person, artificially changed the price. But ultimately, that order came through. Somebody at your company got the order. Somebody put those in a box, right? And sent them the holsters voluntarily. So a change of ownership voluntarily occurred, and you affirmatively allege that, don't you?
No, Your Honor, we do not affirmatively allege that. And if I could just parse a little bit in nuance with regards to the shipment of the goods to the appellees here. So by way of example, if I lend my lawnmower to somebody, say, here's a lawnmower, if you could use it. And then I say, please give back my lawnmower. And they don't give it back.
So that's not the right analogy. So there are two things. Number one, the indication here would be that they fooled you into selling them a lawnmower, right? So maybe they tell you it's broken. Right? Maybe they say, hey, your lawnmower is broken. I can only scrap it. It's not going to work very much longer. I could scrap it for parts and maybe get $100 out of it. Why don't you sell it to me for 20 cents on the dollar since it doesn't work, right? Mm-hmm. And you agree to that. You say, all right, I'm going to sell it to you for 20 cents on the dollar because you're a mechanic. You've told me it's broken. It's not going to be worth much. Okay, they have maybe defrauded you. They've committed the offense of fraud. They didn't commit conversion, right? They gave you money. You agreed to sell them the lawnmower for that money. So that's one problem with your hypothetical. It's just not analogous to this case. This was a sale. It was a voluntary sale, and your person transferred title of property. The second thing is when somebody does wrongfully retain properties, in other words, they acquire it properly, but then they find out it's not theirs, and that can be conversion. That can be conversion, the wrongfully retaining property, even if it was really acquired, but only when there's been a demand to return, right? So the conversion doesn't happen until the other person says, give it back, and you don't. And you don't allege that. So you allege that they got it voluntarily. You don't allege, which would defeat conversion, right? And you don't allege the thing that might put it back into conversion, assuming that they didn't have a right to retain the property. This is the demand.
Yes, Your Honor. And, I know this is outside the record, but they did make a demand for the products back.
Okay, but we're not here on that. You alleged a complaint. You had 3 chances to do it, right? So,
well, the interesting thing about the leave to amend is that there were 3 separate judicial officers that dismissed the complaint. It was Judge Whitehead, Judge Thompson, who's a senior judge in this court, and Judge Netcher. Unfortunately, Judge Whitehead and Judge Thompson didn't delineate a written order, or they'd had a written order, but they didn't explain why they dismissed the underlying complaint. It was only when we got to Judge Netcher that wrote the order there. And I don't even believe that he cited grounds that Your Honor is currently citing. It was more that he took issue that it was bare bones. And again, we availed ourselves of the safe harbor in the form complaint. And to the extent the court is saying that we had contradictory allegations, pleading in the alternative is expressly permitted by the floor rules of civil procedure.
Well, you don't plead in the alternative, right? That's not what you don't say, we bring this claim, and if this claim fails, we bring this other claim. That's pleading in the alternative, or we think this is true, but if not true, that's true. You say this happened, right? And then you incorporate those allegations into the conversion claim. And the thing you incorporate is we voluntarily gave the property in a voluntary sale in which we transferred ownership.
Well, again, if I could push back a little bit on the word sale here, because it's selling a firearm holster worth manufactured sale retail price of $149.99 for the $0.00 is just not reasonable here. And this is sort of analogous to the situation where somebody goes to Walmart, for example, they slap a different barcode on the chattel or good and do a scanning. They scan, a piece of meat that's worth like $30. They say it's worth like 25 cents or a stick of gum. That is, taking somebody else's property without their permission. They should get it back, even if it was under false pretenses. But I guess that sort of leads into our RICO allegation, where we have multiple temporally several instances of fire and mail fraud here. And in our opinion, we pled multiple of those predicate acts and instances. We have 18 USC subsection 2314.
Counsel, if I could just jump in real quick.
Yes, sir.
Also, just going on the long lines, I mean, you made a mention that the first two orders were nondescript, which is true. You know, they just said dismissed, dismissed, and then finally we get to Judge Nettering, he gives a more detailed order. But where are we left with that with no transcript of those original hearings? How do we know that the judge didn't orally somehow announce, somehow give some indication during the argument to say, hey, I'm really finding, there's all these issues, and didn't give that explanation? From an appellate perspective, how can we really give you the benefit of the doubt and say, oh, you must have had no idea until Judge Netcher's written order? Do you have, what would be your response to that?
My response is that if it's not in the record, it's not in the record, Your Honor. It's if the court wanted to put that in the record, those explanations, those details.
Counsel, that means somebody can't establish that advice or that an oral ruling was given. It also means you can't establish that it wasn't. If there's nothing in the record, we just don't know either way.
Well, respectfully, Your Honor, I think that would be rather putting the cart before the horse, or unfair to put it on the appellee to somehow prove a negative. It occurred.
Well, hold on, no one put a burden on you to prove a negative, but you made an assertion, right? You took it upon yourself to prove a positive. You said no information was given from the court. And I think the response to that is that you kind of alluded to it yourself. If there's nothing in the record, there's nothing in the record. So nobody asked you to prove a negative. You made a statement, and that is a statement that neither you nor us can know is true from the record we have before us, correct?
Well, Your Honor, it's and something I like to tell the circuit courts oftentimes. Argument of counsel isn't necessarily fact, and I'm of course making a representation to the court as to what occurred, and it's a Rule 11 representation, federal court, and it's a rule under the Florida bar to making representations. So I am making representation to the court that that did not occur. Again,
Doesn't that mean you're relying on something outside the record, counsel?
I
Are you allowed to make outside the record representations to us and use that as a basis to ask us to rule in your favor?
Well, Your Honor, respectfully, we're talking about the abuse of discretion standard with regards to us granting leave to amend. And so again, with Judge.
Counsel, hold on, that doesn't answer the question at all. Your ability to rely on things outside the record and make assertions to us as matters of fact that you're essentially testifying to is not based on the standard the standard of review we apply. Is there any time in an appeal that you're aware of that you're permitted to give us information outside the record and then ask us to rely on that in ruling in your favor? Is that a thing that's supposed to happen?
Well, it's not a thing that's supposed to happen, Your Honor.
Okay.
Counsel, let me ask you this. I want to focus on the RICO claim.
Yes, Your Honor.
How many predicate acts are demonstrated in the attachment, the spreadsheet that was attached? Over what period of time, and how many separate predicate acts?
I believe it's over a course and scope of 2 weeks, Your Honor. I don't have a particularized number for exactly how many that they are, but I lay them out in the amended initial brief at page 14 through 15. And so we have a list of specifically delineating in the spreadsheet the who, what, where of wire and mail fraud. For example, page 15, amended initial brief, wire and mail fraud, Philip Laurie for thefts of firearm holsters in one transaction, November 18, 2021 at 2:23 p.m. We have his IP address, his address, our current scene.
Are those allegations, is the information that's contained in the attachment inconsistent or consistent with the allegations in your complaint? For example, in your second amended complaint, I think you allege, for example, as to Philip Lurie in paragraph 6, from October 30th, 21 to the present, I guess, being whenever this was filed in mid 23, Lurie caused packages to be delivered to, and then you go on. So is that allegation inconsistent with the information that's contained in the attachment? And if so, what difference does it make? What difference should we concern ourselves with, if any?
So, Your Honor, of course, when we file a complaint, it's a snapshot about what we know at that particular point in time. So those are the transactions and shipments that we are aware of. But in any event, to the extent that it is contradictory, which I don't necessarily see that it is, given the nature of pleadings and complaint in a court, it's that they still have the goods. They didn't give them back. They didn't give back the firearm holster. They didn't give back the proceeds. They still retain the benefits of it. And that is inconsistent with my client's ownership interest in it. And it's an ongoing fraud, and it's an ongoing violation of the 18 USC 2314 and 18 USC 2315. And those are the federal RICO's predicate acts relating to interstate transportation of stolen goods with a value in excess of $5,000 and relating to receiving or selling stolen goods in value excess of.
Councilman, how are those not inconsistent? So you've got allegations that this occurred over a period of a couple of months in your complaint. And then paragraph 22 of the complaint says plaintiffs hereby incorporate Exhibit A, which is a spreadsheet of each instance.
Mm-hmm.
So you represent that the spreadsheet contains all the instances. And the spreadsheet only shows 4 days. So as far as I'm aware, I haven't been a trial judge in a while, but when you have an exhibit and a complaint and you attach the exhibit to the complaint, to the extent of a contradiction, the exhibit controls.
Mm-hmm.
Right? So explain to me how they're not contradictory. If you said, here's a few examples, I can see that. You didn't say that. You said each instance is on the spreadsheet. Spreadsheet has 4 days, not 2 or 3 months.
Well, Your Honor, I think that's splitting the hairs a little bit.
It's not splitting the hairs at all. You made a statement in your complaint that the spreadsheet contains each instance.
Yeah. I respectfully, Your Honor, I just disagree with regards to the contention that it's not, sort of splitting hairs and nitpicking there. Doesn't change the fact that the defendants and appellees in this case stole 205 firearm holders from my client. And in fact, we're aware that they tried to steal $50,000 more worth of firearm holsters.
Counsel, in what sense is that splitting hairs? You say it contains each instance and it has 4 days, and your complaint, the body of it says it took place over a period of a couple of months. Go into some detail on that for me. How is that splitting hairs as opposed to just not seeing an obvious contradiction?
Well,
Is it just you wish you would have used better words, or different words?
Well, Your Honor, I believe we cited some case law in our amended initial brief that our courts of Florida, they shouldn't be necessarily concerned with the tricks of the trade with regards to eating. It's Cobbett versus Clearwater.
Counsel, what you're implying is that this is a trick or some kind of hyper technical or unfair reading, right? And I understand you've made that assertion.
Mm-hmm.
And I'm asking you to go deeper and explain to me how. Okay, because I don't think it's an unfair assertion. I think it's an accurate assertion. So if you're going to tell me it's not accurate, that's fine. Explain it. Don't just say, well, that's hyper technical.
Yeah.
I have words, and the words seem to say the spreadsheet contains everything. Why is that an unfair reading based on the words you used?
Well, Your Honor, it's an unfair reading in light of the fact that we initially brought this claim as the most milquetoast cause of action in the state of Florida. Ken Burden, you have our stuff, give it back. The claim was dismissed with leave to amend the state more facts. We went ahead and did that. It was again dismissed without an elaborate order. Didn't detail what was wrong with the allegations. We went ahead and looked at the fact and said, wow, there's digging in these facts. It turns out there's RICO issues here because they're all there's temporally several instances of wire and mail fraud. They still have the stuff and they've been selling it. They've been fencing the goods. And so to zero in on one line in a several page complaint with detailed allegations and toss it out and say it's contradictory, Judge, I think that's unfair.
Okay, hold on.
Counsel, you're in your rebuttal time, so.
I don't see how that shows it's not contradictory. It just shows you think it's not fair to look at this part of the complaint.
And if you want to save the rest of your time for rebuttal.
Yeah, Your Honor, if we could just reserve the time.
Sure.
Mr. LaRosiere to address it. Thank you.
All right, Counsel, you may proceed.
Good morning, Your Honors.
Morning.
My name is Julianne Brumball, and I represent the appellee, the Bernstein firm. And I'm going to be arguing today on behalf of my client as well as the other appellee, Gundog Armory Incorporated. Your Honors, just as the complaint suffered, the argument that we've heard from the appellants today suffers the same deficiencies. There's been conclusory statements without sufficient facts or legal support to support their position. The legal support that has been provided in their briefing is insufficient and in certain situations misleading. Appellants have cherry-picked favorable statements from cases that upon reading do not actually support their position.
Counsel, if you could just kind of narrow in, I know we got multiple claims here, but the conversion claims, how do you feel that your client was not put on notice of a conversion claim based on the Second Amendment complaint?
Thank you, Your Honor. I believe that Your Honor, Mize has already addressed that to some extent in the fact that there are contradictory allegations within the pleading itself. The initial complaint was filed. It was unlabeled and just had 3 counts that we presumed were meant to be conversion claims. It was dismissed at that time. As my colleague has admitted, it was dismissed for failure to state sufficient facts.
How was that insufficient when it followed what the Florida rules say a conversion claim is supposed to put out there?
Your Honor, that is an interesting point. And how we look at it is the fact that just because the Florida Supreme Court has issued these forms that are meant to guide litigants in how to plead a case, presumably to help pro se litigants know what to do, it is still required to follow the rules of civil procedure 1.110B that requires a plain and short statement of ultimate facts that show that the pleader is entitled to relief.
Aren't there like several cases? At least I saw a couple. I did see those where all they had was the form. They didn't have anything else. Trial courts dismissed it and DCA said the form's sufficient. I mean, are you saying those cases don't exist or that we should disagree with them?
No, Your Honor. I believe that this is distinguishable, and I do apologize. I don't have those cases in front of me, but I believe this is distinguishable because of the conflicts and the allegations.
So it's not that the form is insufficient. It's that they have things outside the form in addition to it that defeated their claim.
Yes, Your Honor.
Which part of it do you find is insufficient? If we focus again, just on the conversion, I mean, essentially, when I look at their Second Amendment complaint, it says, Lurie hacked into our website at the behest of the other defendants and obtained these things wrongly for free, essentially, other than shipping. And so we're entitled to get paid for it. I mean, what else do you need for a conversion claim? I'm not talking about RICO and I'm not talking about computer fraud, but just for conversion. I mean, why can't you adequately defend yourself from conversion with those allegations? Because when I read it, that's kind of what it boils down to me. Your actor at your behest obtained these things wrongly for no money, and we're entitled to get paid.
Your Honor, to some extent, I believe that it could have been curable. However,
Well, forget curable. What's wrong with those allegations from a conversion perspective? You got it wrongly. It's worth money to us. We want money for it.
Your Honor, it comes down to the dominion element of conversion, which requires that there has to actually have been some wrongful taking or wrongful retention.
But I mean, he alleges that all over the place, you know, essentially that, again, whether they can prove any of this is a completely different story. But the allegation is that Lurie hacks into the website, obtains these things from them for no money, and that you obtain them somehow from Lurie, had it shipped to various places, and we're selling them at a price less than the manufacturing. And, you know, he's got pictures of somebody selling them and all. I mean, that looks like dominion. If they're in your store and they're being sold, if they can actually prove any of that stuff.
Yes, Your Honor. And I do agree that had they pled the sufficient facts, the issue comes into, and to some extent, this is where it gets technical, In their initial complaint, they stated that the defendants stole 205 holsters. However, in the actual claim, again, particularly my client, the Bernstein firm, it alleges a different amount was stolen. That is an issue that has been carried throughout the various pleadings.
But in the general allegations of fact, isn't the allegation that there was a total of 205 stolen, but it was in various increments, and 20 went to this person, and this went to these fake names, but they were all going to the same address. So I mean, in the aggregate, it may add up to 205, but if he can only prove that Mr. Height got 20,
Mhm.
I'm not seeing that those things are inconsistent. At one part, he alleges the aggregate number of holsters that were taken allegedly. And in the individual conversion, he said, but Mr. X only got 20 of them, or whatever the number is. Again, I don't want to waste all your time on the conversion, because the more interesting issue, I think, is the RICO claim. But I'm just having a hard time understanding what else did they have to say, not the bar exam version of conversion, but what else would be necessary for them to allege conversion? What's missing?
Your Honor, my understanding of how they've pled it, and based on under the trial court's ruling, it's my belief that it wasn't necessarily that they needed to add additional facts. It was that they needed to remove the conflicts between the allegations that they did raise and the overarching issue, which is the lumping of the parties. They lumped together not only the defendants, but also the plaintiffs, which creates some confusion because there is no clarity as to who the activity group is. That has been an issue that has promulgated this entire case.
What is the conflict as you identify it?
The conflict, Your Honor, is multiple. I mean, to some extent, what I've already addressed, that it says the defendant stole 205, and then particularly to my client, it then reduces that number to a different
Is
amount.
that a conflict that defeats a conversion claim?
Your Honor, that is a good question. I'm not sure if it does. Had this been a situation where the defendants, or excuse me, where the appellants had made any opportunity to amend their cause of action based on the guidance from the court, it may have been something that they,
Sounds like you're conceding they should have been able to amend, or that it doesn't defeat their cause of action.
to some extent, Your Honor, I am, because it is, had they actually pled the allegations and clarified the contradictions and not lumped together defendants, it is something that they perhaps could have cured.
So do you agree they should have been given leave to amend?
I do not, Your Honor.
Seems like you just said you do.
Your Honor, yeah, the issue here is that amendments are not just freely given. While they are they are meant to be freely given. However, there are exceptions to that issue that the court has to look at, which is whether or not the amendment would prejudice the opposing party, whether or not the privilege to amend has been abused, or whether or not the amendment would be futile.
All right, well, you've conceded it's not futile because you said they could have fixed it. Which one of those applies here?
Your Honor, as to the abuse of the amendment process, the trial court had dismissed their first complaint and their second complaint based on our arguments about the insufficiency of the conversion claim. And despite, essentially kind of having a roadmap as to what my clients believe needed to be
Where did
cured
they get a roadmap from?
from our motion to dismiss, Your Honor.
Okay.
Counsel, let me ask you to turn to your lumping thing.
Yes.
As far as the argument, they say Philister and the activity group plaintiffs, and they say that plaintiffs manufacture and sell firearm holsters. Why can't two different companies get together and manufacture holsters? I mean, what's the problem with that allegation? Yeah, okay, go ahead. Sorry.
No, it's okay, Your Honor, and I apologize for interrupting. I mean, it is something that they both can do that. And that would be a situation where that wouldn't be an impermissible lumping of them to say that the plaintiffs are involved in that action.
They said plaintiffs manufacture and sell.
Yeah, I know what they alleged.
I mean, what else do they need to say? You and I are partners and we manufacture holsters.
And Your Honor, this may be an issue that No, and I apologize. I believe it is in of the record. The issue is that we've been told some of the activity that the activity group, or we've never been given any explanation of what the activity group actually did. Based on a filing by Mr. Laurie, it appears that the activity group was the shipping company that sent the,
Counsel, how is that in the four corners of the complaint? Like what, the supposition here is that there's something about the plaintiffs being lumped together that defeats their cause of action as at a motion to dismiss stage, not whether they'd eventually have to flesh that out. And I think what Judge Orfinger has pointed out is two people can own holsters together, and if it's stolen, they're then both the victims of the theft or the conversion. So you pointed out a couple issues where you think are deficiencies, but I'm not seeing where these defeat the claim. So you pointed out that the plaintiffs are lumped together. I don't know how that affects the elements of conversion claim. You pointed out the difference in the number of holsters. I agree, that might be a slight conflict, but in order for you to win, it would have to be a conflict that defeats the conversion claim in some way. So how does lumping the plaintiffs together, or this other conflict you've identified about the number of holsters, how does that defeat a conversion cause of action?
Your Honor, the issue here is that the allegation is that the Filster group owns the holsters. There was no allegation or clarification as to how the activity group was actually involved.
But it says on paragraph 3, first off, we've got the identity of the plaintiffs, Filster and the activity group. And then paragraph 3 of the second amended complaint says plaintiffs, plural, manufacture and sell firearm holsters and other accessories. I mean, to me, I was thinking like, okay, so Jack and Jill bake a cake and defendant X stole the cake or converted the cake. What difference does that make? It was one cake or it was multiple cakes? Who cares who made the cake? Who cares who put in the flour and who added the sugar, who stirred, who put it in the oven? This is saying that these two companies are working together to make these, and you all converted them and did other things. How does that not put you on notice that there are holsters that came from one website and one location that are now in your possession that shouldn't be in your possession? How does that, and there was a bad actor that they're alleging was your agent, Philip Lurie. How does that not put you on notice and give you an ability to defend this case? How can you not defend this case because you don't know whether Jack or Jill baked the cake or whether Filster or the activity group, put the stitching on and the other person put the brads in? What does that make a difference?
Your Honor, quite frankly, I don't think it does. I think the primary issue, and if you, I'm sure you have reviewed the underlying trial court's order, the issue of lumping of the plaintiffs is just a footnote.
Right.
Yes.
So let's get to the defendants then,
Yes.
which I think is the bigger issue. And again, from a notice perspective, I'm having a hard time understanding how you're not on notice when the facts, to me, are pretty clear. You've got this guy, Philip Lurie, who is an alleged agent of the Bernsteins and the others, who goes out, hacks into the website, gets these holsters and gives them to you all to sell at a reduced price, gets them for free, which is the conversion portion of it. How is that not, again, put you on notice? Where show me in the complaint where you're so confused that you can't defend yourself. This hasn't put you on notice as to what they're saying you all did wrong and what you need to do to refute those allegations.
Your Honor, if this were just a claim for conversion.
Well, that's what I'm focused on right now. I mean, for me, that's my big focus. I know there's some legal issues with some of the other ones, but I'm having a very hard time on the conversion claim, finding that y'all weren't put on notice that there were conversion claims that were out there.
That's fine, Your Honor, and I think that is a fair point. And that is why I think it's clear from our briefing as well as the underlying that was more or less just an afterthought to some extent. It was something that the court dismissed simply because they were lumping them together. They are required under, like, as I stated, Rule 1.110B to do a short, plain statement to inform the defendants as to what is being brought against them. And I do understand that it is, to some extent, to use my colleague's phrase, splitting hairs, that, I would concede the point to some extent that I think the primary issue is the fact that they were provided with 3 separate opportunities to amend their complaint, and 3 separate times they have
Counsel,
presented.
but you seem to concede that with the conversion, you seem to be conceding they stated a claim for conversion.
I
They don't need to amend no matter how many opportunities if they've stated a claim. I mean, you saw I concede the point, right? So if the conversion claim is sufficient, they didn't have to avail themselves of any further opportunities, and the motion to dismiss should have been denied, should it not? At least as to the conversion claims.
It's our position that the court was proper in utilizing its discretion to, or excuse me, this is the granting of the, or denial, the granting of the motion to dismiss is reviewed de novo. So I do understand that, you know, it would be, it may be something that is, it is a weakness of our position. However, it is our position that the trial
Counsel,
court.
do you concede that the conversion claims are sufficient? I get your argument about the racketeering claim. Did the conversion claim state a cause of action as stated in the second amendment complaint?
Your Honor, I can't concede that simply because of the contradictions between the allegations in addition to the spreadsheet that also further contradicts.
Okay, so the contradictions, is there any other reason other than the contradictions?
No, Your Honor, not as to the conversion. claim.
Okay. The contradictions I see are the number of holsters, okay, and the dates of the transactions. And I see those seem to be clear, obvious contradictions, and I don't think you could seriously consider them not. Right? They're obvious contradictions. But what about those contradictions defeats a conversion claim? Because in order for the contradiction to mean that they didn't state a claim, the contradiction would have to defeat the claim in some way, right?
That is correct, Your Honor.
Okay. So what about those contradictions defeats a conversion claim?
That is a good question, Your Honor. I mean, in our position is simply just the issue that it might not necessarily have defeated it. However, because they were given those opportunities and the court granted our motions in which we stated that the conversion claims were insufficient. And then subsequently, when the trial court actually wrote the detailed order, stated that the conversion claim failed simply due to the lumping of the defendants.
Sometimes you're sorry you asked for the relief that you get, but
That is,
Now,
Your Honor, yes,
It sounds like you agree, but for the contradictions, the conversion claim states a claim, right?
yes, Your Honor.
let's talk.
And you agree, hold on. And you agree that none of the contradictions defeats a conversion claim, right?
I don't believe it would, Your Honor, no.
Let's talk a little bit about the computer fraud. As I understand that statute, basically, if you have a protected computer and you do things in that computer that are improper, you've stated a claim under the computer fraud. And it's a little bit, I mean, I'm very simplifying, but, and as I understand the cases, almost every computer that's in the stream of commerce that's connected to the internet is considered a protected computer. So what is it about that particular claim, the computer fraud, that's problematic? Because they've alleged they're a protected computer, that they're in the stream of commerce, that they sell guns and accessories and stuff over the internet. I don't know about guns, but accessories over the internet. And that there was hacking that went on that resulted in a transaction for $0.
Mhm.
Tell me specifically what it is about that claim, coupled with the general allegations, that doesn't state a cause of action.
Your Honor, as a preliminary, I will state that we concede that the protected computer, based on the judge's order, did qualify as a protected computer. The issue that we rely upon, or the reason for the dismissal that we rely upon, is what the trial court pointed to, which is the impermissible lumping of the defendants. And while that may not have been an issue on conversion, there is a heightened pleading requirement that is necessary for claims that are sounding in fraud.
But when we talk about the lumping, I mean, between his general allegations in paragraph 6, Lurie acted as an agent for, and then he names all the other defendants. And then his enterprise allegations that, you know, all of these folks were associated with an association, in fact, with the Bernstein enterprise and engaged in a scheme to defraud, et cetera. What is it about that that's causing the lumping? I mean, basically, he's saying that this was a conspiracy amongst all the defendants to hack into the computer and sell these things for a reduced price.
Your Honor, the issue there is the fact that there is case law that states that they are required in claims for RICO that are sounding and prod to assert allegations as to each defendant, so that each defendant is made aware of the specific acts of fraud that they're alleged to have, or specific conduct that they have.
And I know we're past time,
Thank
but isn't that what they did? Philip Lurie hacked the website. Philip Lurie was the agents for Mark Bernstein, Casey Height, Bernstein firm, Gundog Armory, and then they got the goods. And doesn't the later use of the word defendants in plural with a reference back to these other facts that are much more specific, just really say everybody was kind of working together? You know, look back to paragraphs 1 through 28, and there you go. That's how they all work together. How does that not, again, put you on notice that?
It's our position, I apologize, Your Honor. It's our position that they are just simply conclusory statements. There are no allegations to state how they acted as an enterprise or what activities that they did. And if I may just address one point in conclusion that we discussed earlier, is the continuity of the RICO charges. There is case law that states that apologize, Your Honor.
Are you about State v. Lucas counsel?
Excuse me?
About State v. Lucas?
Yes, Your Honor.
It's got to be a period of at least a few months.
Yes, Your Honor. And it states that when there's no threat of continuing criminal activity, that is not sufficient to meet the requirements under RICO.
I have one more question. Counsel, if we agree with you on the racketeering claim and we disagree with you on some or all of the other claims, what do we do? Do we say that the dismissal is properly with prejudice as to racketeering, but not with prejudice as to conversion? Do we reinstate it as to conversion? What does this look like if we think you're right on racketeering and wrong on the rest?
Your Honor, I believe at this juncture, it would be appropriate to dismiss those claims that you agree with us on with prejudice, simply because of the elements that are required to be considered for motions for leave to amend. They've been provided with sufficient opportunities to do it and have.
The RICO claim didn't come in, it wasn't in the first complaint. So they haven't had 3 chances on the RICO claim, have they?
No, Your Honor, they've had 2. That's where it goes back to there is no magical number as to how many amendments should be given, but instead it focuses on the number of ineffective attempts that have been made. And the issue here isn't only that it was ineffective, it's that the appellants have stated that they aren't required to make the changes, that there are no heightened pleading requirements. They have simply continued to disagree with the court every step of the way. And it's our position that that would only continue if they were provided with additional opportunities. Thank you, Your Honors.
Thank you, counsel.
Very good.
Counsel, I'm going to give you a few extra minutes because we gave her a few extra minutes. If you need it, if you don't need it, that's fine.
Thank you, kindly, Your Honor, and may it please the court.
You may proceed.
I'm Matthew LaRosier for Filster and the Activity Group, and we've heard a lot of different things about racketeering and conversion and all this other stuff, but a lot of focus was on conversion, and I think there's for good reason. And it's because conversion is something that developed as an element of procedural fairness. And I think that where we're at in this appeal is all about procedural fairness. And I do think it's very interesting that the case that the lower court cited for the proposition of dismissing this with prejudice, Praedus v. City of Naples, that very case, the granted pro se defendant was given multiple written directions as to why his claim was defective. And still, in that opinion that was cited, the lower court was reversed for dismissing it with prejudice. We have to remember that conversion is a gap-filling issue. And I understand that this situation is kind of hard to get your head around, right? You know, we're trying to nail down 3.
So, can I ask you about I thought that hypothetically, your your co-counsel gave about the changing the price tags in Walmart was a good one. And I just, can you go into that a little bit more about whether or not that's fraud or conversion? Right, so
Absolutely.
you know, here he said if you change the price tags to 0, they won't actually change to 0 here because something was paid. I think shipping was paid, you allege, right? So they paid something for these holsters.
Mhm.
If you went into Walmart and just took something, obviously that's conversion. If you went into Walmart and or hacked their system and changed the price from $20 to $10, and then went up to a register and Walmart gave it to you for $10. Is that conversion or is that fraud? And the reason I ask is if you look like the common law of contracts, how common law of contracts looks at the store situation is that displaying prices is actually an invitation to make an offer. Okay. How you put the common law of contracts onto a store. When the customer approaches the checkout counter, they're technically making an offer.
Right.
And when the cashier checks them out, they've accepted the offer. Okay. So what you have when you set those prices is an invitation to make an offer. Okay. And according to his example, what you've really done is like kind of fraudulently change the invitation. Right. And then you go up there and you make the offer of the reduced price and the person accepts it. Is that conversion or is that fraud?
So it's really interesting, Your Honor, and I think we don't have to go to the Walmart hypotheticals, as fun as they might be, because we have the early English case law that developed this tort that we're still dealing with and how awkward it is today. You know, Mount Eagle v. County of Worcester, that was a pretty dang similar situation where somebody took a chain, sold it, and pocketed the money. The things that are in conversion
Well,
are
get in that case, right?
but it was never alleged that it was stolen. It was silent. The only thing we knew about was the sale. And it was because, and that's why these elements developed, and they're common law elements, they're not statutory. So plaintiff demonstrates a right to some possessory interest. I think we've got that. There are. So
No, I'm challenging that. I'm challenging whether you have a right to possessory interest because they made an order, right? A monetary order. You allege it did have money because you allege it had shipping and handling, right?
Mhm.
Your client accepted that order. Now you accepted it on false pretense. The false pretense was that you had originally set that as the invitation, right, as the price. But ultimately, they made an offer under contract law and you accepted. That would mean you don't have a right to possession. Now,
So-
you maybe you're the victim of fraud and you've got a fraud claim, but that's different than having a right to possession of the property.
This is really interesting, and I adore this because it is a common law
I
issue.
need you to do more than adore it.
Yeah, I know.
Give me an answer.
I am giving you an answer. So the dominion question is where this actually comes into place because you have wrongful dominion, which is the core element of conversion, when there is some wrongful action. And in the case law going back through state case law and all the way back to English case law, one of the earliest ones was a similar thing where there was, in law school, we all read about the cravat where 1 shilling was thrown down and the cravat was taken. That was a conversion. This is similar. Silence does not establish a perfect contractual situation. What do we hit? And you know what? The facts are not exactly before us. We don't know that there was a completed acceptance. All that's alleged is that
No, counsel. You allege there was a completed acceptance. You allege that they ordered the holsters, right? And that order was accepted, completed, and the holsters were mailed. So you allege the purchase, the sale completed all voluntarily. Now you say it was under a false pretense because they changed the price. And what I'm asking about that doesn't mean there wasn't an accepted sale. There was. You affirmatively allege there was. We know that for a fact because that's what's alleged in your complaint.
we allege computer hacking. So, and this is, it's fun to reverse engineer these into this contractual stuff because frankly, it doesn't fit right. And that's why we use gap filling claims like this, because it doesn't fit right. You're not, with the Walmart example, it's great because there's a human being that you can depose and say, you handed it over for $0, right? That's not what happened here. We're dealing with a computer that they hacked. So
Well,
was there even an acceptance?
That's not true, counsel. You guys processed this order, okay? You received the order, you put it in a box and you mailed it to them and you accepted money in the form of the shipping and handling. All of that you allege. Okay, so it's not like we don't know if it went through. You allege it went through. Okay, the only thing you allege that you say makes it a conversion claim is that they tricked us into doing that at a lower price than we otherwise would have. I'm really struggling whether that's conversion or fraud.
And so maybe it should have been worded better. And I agree with that struggle. I think it could be both. I happen to believe that fraud is a sustaining any fraud. And in fact, the case law refers to subsequent fraudulent sales, sustain conversion. So I think the fact is there's some ethereal fraud that we know from the face of the second amended complaint, which I think is sufficient to sustain conversion. And I understand your resistance. I understand it completely, but that gets back to the procedural fairness issue where it's clear as day. How
Are
much
you basically saying, counsel, it's clear they did something wrong, so don't make us state a specific claim?
No. There's nothing wrong with stating a specific claim, but the plaintiff, it should not be, we should not reward defense gamesmanship to prevent plaintiff from ever getting into
Is this
discovery.
defense gamesmanship to point out you haven't stated a conversion claim, counsel?
What more could really be said from the perspective of the plaintiff that all we know, we made these things, they got into our computer, it wasn't supposed to do that. They paid zero, they got them, they're selling them for less than it costs us to make them. So we know something bad
I
happened.
guess say that about anything. You could have brought a securities claim and you say, well, something's wrong. Just let us bring, no, you have to bring the right claim, counsel. You don't just get to bring any, you don't just get to say something's wrong and therefore there's a claim. You have to bring the claim that actually matches the wrong you're going after.
Yes.
And so to just say, well, there's something wrong, so uphold our conversion claim, that doesn't get you there. You've got to have stated a conversion claim.
I completely understand, Your Honor, and that's the most frustrating thing about this case is that we were never told what was going on. And you rightfully grilled my co-counsel on, well, what was actually said. We don't have it on the record in front of us. And my colleague on the other side had her own representations as to why that complaint was thrown out. We don't know.
Hold on. She based hers and she said, we gave them roadmap in our motion dismissed. That's on the record. Your co-counsel made a factual misrepresentation completely outside the record and asked us to rely on it. Very different things, correct?
Yes.
Okay.
Yes. And I think but I think that the frustrating thing for all of us here, for you as jurists and for us as appellants, is that we don't know. It's not on the record. And I think that the procedural fairness for leave to amend, which should be granted liberally, and only denied when somebody has abused that privilege, right? As is cited in Harrison, is because I think it's pretty clear. It was brought in good faith. There may be some issue that the drafter of the complaint failed at, but that shouldn't go all the way to creating such a.
Let me ask you one more thing about the racketeering claim before I let you go. There's a State v. Lucas, all right, that's 1992, and it refers to a U.S. Supreme Court case from 1989. Saying that in order to have enough continuity or longevity to be an enterprise, a few weeks or even a few months is not enough. Okay. The body of your complaint alleges a couple of months. The exhibit seems to completely contradict that and allege 4 days. Either way, that's not several months that the Supreme Court said was required. I did look. I didn't find anything since 1989 changing that. 1989 seems to be the last time the Supreme Court has discussed this. That means it's binding on us. Right there, you get to tell us what to do in terms of you brought a federal RICO claim, so we're bound by the U.S. Supreme Court. They say this time period is not long enough. What am I missing?
I think the most important thing that's being missed here by focusing on the attachment is the fact that so a bank robbery, whatever kind of robbery that happens in 1 day. Then the real work, the real criminal enterprise is fencing and getting rid of those goods. And we do allege that. Do we know exactly which day?
Counsel. The Supreme Court said you have to have a certain period of time. Okay. You do not allege that period of time. You have a complaint that alleges a couple of months. The Supreme Court said even a few months is not enough. And you're below that, even in the body of your complaint. And then the spreadsheet says 4 days. Right. And the case law is the spreadsheet controls if it's attached and it contradicts. Right. None of those establishes the period of time the Supreme Court has said is required.
So I would resist that it contradicts because again, the spreadsheet only shows the actual transactions of shipping these over. The real work, just like in other racketeering situations, is what you do after the fact. And we did allege that there was fencing and shipping over state lines. We did know and allege that they were shipping these over the internet. So if that is deficient, funny thing is, the only way that could be cured would be to have brought the complaint later and then given them more time to do this. But I am a little confused because again, a lot of the order below incorporates 11th Circuit pleading standards that are foreign to this jurisdiction. So Forgive me that I'm a
Council, we
little,
are past times.
So sorry.
Did you have anything? Okay, all right. Thank
Thank
you,
you.
council. Appreciate it. Thank you both.